The Supreme Court this morning hands down its judgment in the matter of A and B against the Criminal Injuries Compensation Authority and another. I should explain that the court has ordered that no one shall publish or reveal the names or addresses of the appellants who are the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of the appellants or any members of their family in connection with these proceedings. The appellants in this case, A and B, are victims of human trafficking who are excluded from compensation under the Criminal Injuries Compensation Scheme on the ground of their previous criminal convictions. The Supreme Court is asked to decide whether this gives rise to unjustified discrimination against them in breach of Article 14, read with Article 4 of the European Convention on Human Rights. The scheme is a statutory scheme made by the Secretary of State for Justice under the Criminal Injuries Compensation Act, 1995. Compensation may be awarded to a person if they sustain a criminal injury which is directly attributable to their being a direct victim of a crime of violence. However, because of an exclusionary rule, an award of compensation will not be made to a person who has an unspent conviction for an offence which resulted in a custodial sentence. The appellants are twin brothers and Lithuanian nationals. The first appellant, A, was convicted of burglary in June 2010 by a Lithuanian court and was sentenced to a 3-year custodial sentence. The second appellant, B, was convicted of theft in December 2011 by a Lithuanian court and was sentenced to an 11-month custodial sentence. In 2013, the appellants were trafficked from Lithuania to the United Kingdom and subjected to labour exploitation and abuse. Their treatment constituted criminal offences for which the traffickers responsible were convicted and sentenced to custodial terms of 3.5 years each. In June 2016, the appellants applied to the Criminal Injuries Compensation Authority for compensation under the scheme. Their applications were refused because of their previous convictions. The appellants brought a claim for judicial review against the authority and the Secretary of State. The appellants argued, amongst other things, that the exclusionary rule was not compatible with the European Convention on Human Rights, as given effect in domestic law by the Human Rights Act 1998. The High Court dismissed their claim. The Court of Appeal then dismissed their appeal. The appellants now appeal to the Supreme Court, which unanimously dismisses the appeal. The court begins by explaining that the prohibition on discrimination in Article 14 of the Convention is not a freestanding prohibition on discriminatory treatment. It prohibits discrimination only in the context of the enjoyment of the rights and freedoms set out in the Convention. As a result, the appellants need to establish that the exclusionary rule is sufficiently closely connected with one of the substantive Convention rights in order to bring Article 14 into play. The court concludes that these appellants can do so. By applying the scheme to victims of trafficking, the United Kingdom has chosen to confer a degree of protection to promote their interests. In doing so, it's applying a measure which has a sufficient connection with the core value of the protection of victims of trafficking under Article 4 of the Convention, which prohibits slavery and forced labour. The rights voluntarily conferred under the scheme must therefore be made available without discrimination. The next matter for the court to consider is whether the appellants enjoy a relevant status within the meaning of Article 14. The court finds that they do. They are victims of human trafficking, and they have unspent convictions which resulted in custodial or community sentences. These are identifiable personal characteristics which have significance independent of the Criminal Injuries Compensation Scheme. Each is therefore a relevant status for purposes of Article 14. The question then is whether the exclusionary rule gives rise to a difference in treatment on the basis of either or both of those statuses. Two matters must be considered here. First, discrimination may arise where the state fails to treat differently people whose situations are significantly different. The court concludes that the scheme is not discriminatory in this sense. There is no feature of the offence of people trafficking which would require preferential treatment to be accorded in the present context to victims of trafficking over victims of other serious crime. Secondly, discrimination may arise where people who enjoy a relevant status are treated differently from people not sharing that status who are in a similar situation. The court concludes that the scheme is discriminatory in this sense. Clearly, there is a difference in treatment between victims of trafficking who have relevant unspent convictions and who are therefore denied compensation, and victims of trafficking who do not have such convictions and are therefore not denied compensation. Individuals in both groups might be victims of crimes of violence, and so, but for the exclusionary rule, would both be potentially eligible for compensation under the scheme. The next question is whether this treatment can be justified. Differential treatment will not breach Article 14 if it can be justified. The court considers that the test to be applied when considering the question of justification in the present case is whether the decision to adopt the measure under challenge was manifestly without reasonable foundation. This follows from a number of features of the case, including that the scheme operates in the field of social welfare policy, where courts should normally be slow to substitute their view for that of the decision maker, and that the scheme was approved by Parliament. The status relied upon by the appellants is also not within the range of suspect reasons, such as sex and race, where discrimination is particularly difficult to justify. Applying that test to the facts of this case, the court finds that the scheme is not manifestly without reasonable foundation. It pursues the legitimate objective of limiting eligibility to compensation to those deserving of it. It is also proportionate. This is an area in which a considerable degree of latitude is accorded to the legislator, and in which it is appropriate to adopt bright-line rules in order to promote clarity and consistency. The scheme takes a graduated approach to withholding or reducing compensation, reflecting in various ways both the seriousness and the age of a claimant's previous conviction. In those circumstances, it is clear that the measure is no more intrusive than it needs to be, and that it strikes a fair balance between the competing interests at stake. The exclusionary rule does not, therefore, give rise to unjustified discrimination in breach of Article 14 of the European Convention on Human Rights when read with Article 4. The appeal is accordingly dismissed.